You have rights, even if you're on house arrest. After someone is arrested, their first question is, how do I get out of jail? A judge usually reviews the arrest within 72 hours and determines if the person is a flight risk or a risk to the community or the victim of the alleged crime. Depending on the facts and the attorney at the detention hearing, the judge may release them on their own recognizance, may release them with conditions that must be met, or may determine to hold the defendant in jail pending whatever the next hearing is. If someone is arrested for serious enough crimes, like capital murder, or when they are charged with a new criminal case in addition to an existing criminal case, the judge can decide to keep them in custody without bail. The circumstances where this can happen are limited, and even when met, can sometimes be overcome by a skillful advocate. When a person arrested first appears before a judge, the judge needs to determine if the person can be released without posting any money bail. If a person is released on what are called non-monetary release conditions, these release conditions can vary from own recognizance release. A person can be released on intensive supervision, or ISU. They can be released on what's called the electronic monitoring program, or EMP for short. Each of these types of releases can be accompanied by additional conditions, like staying away from the named victim or a specific place or area. In addition, the OR, or own recognizance release, the ISU, intensive supervision, and EMP, electronic monitoring program, all have their own individual conditions. These conditions can also sometimes be coupled with a requirement to post what's called an appearance bail bond, or cash bail. If the judge determines that money bail is necessary to ensure a person's appearance at court or to protect the community, the judge will require an appearance bond, or what's commonly called a bail bond, to be posted. Bonds can be posted in cash or by contracting with the bail bonds company to post the entire bond on your behalf. Before a bond is accepted by the court, sometimes the court will require what's called a source hearing. A source hearing is simply an evidentiary hearing where you, as a defendant, or whoever you're having help you with the posting of the bond, provide proof to the court that the money for the bond comes from what's called a lawful source. Source hearings, though, can be dangerous. They include sworn testimony, affidavits, and while the state doesn't really have an interest in the posting of your bail, they do have an interest in where your money comes from. So before you go forward with a source hearing, it is advantageous and necessary to look for a skilled advocate. My law firm can help you understand the legal process, help you build a strong defense against the charges, and work towards a favorable outcome for your case. Contact us today for a free case assessment. Law is war, and your life is worth fighting for. ATAC Law. Your best defense is a good offense. Call now. I get a lot of questions about people who are released and what the conditions mean and what they can or can't do. One of the questions that I get is, can I work while on the electronic monitoring program? The answer is yes, of course you can. Participants are able to work while on the Clark County Detention electronic monitoring program. All employment will be verified at the time of intake, and an advance schedule is required. But yes, they will work with you to make sure you can maintain your job. If not, bring it to the attention of your attorney. He can do something about it. I know I could. Law is war, and your life is worth fighting for. ATAC Law. Your best defense is a good offense. Call now. Sometimes I'm asked, can I go to medical appointments? The answer is yes. Medical appointments are permitted with verification and prior approval. Medical emergencies that require immediate medical care are the only exception to the prior approval rule, and you must have proof of the exigency or the emergent nature of the medical care that needed to be provided. Do I have to wear an ankle bracelet for the entire time that I am on the EMP program? Well, the answer to that is yes. That's what EMP stands for, Electronic Monitoring Program, and a tamper-proof GPS device will be required to remain on your ankle for the duration of the time that you're on the medium or high-level electronic monitoring program. However, if you're on the low level of the electronic monitoring program, and depending on when you're listening to this, make sure you check with your attorney, because they're looking at making some changes to the low-level electronic monitoring program, and that may do away with the ankle bracelet requirements.
Law is war, and your life is worth fighting for. ATAC Law. Your best defense is a good offense. Call now.
Sometimes I'm asked, what happens if I violate the electronic monitoring program requirements? Well, depending upon the level of electronic monitoring that you've been placed on, you can be immediately taken back into custody and returned to Clark County Detention Center. Now, the good news is that because of a case that I argued in front of the Supreme Court called the Johnston decision, you are entitled now to a speedy determination by whatever court that you're in front of at that time as to whether or not you in fact violated the requirements of the electronic monitoring program. But bear in mind, generally the EMP personnel are going to take you into custody first and you get the hearing second. So get a good lawyer and let him know as soon as you've been taken into custody.
Law is war, and your life is worth fighting for. ATAC Law. Your best defense is a good offense. Call now.
What happens if I tamper with or lose the device? What LVMPD will tell you is that if the device is tampered with or purposely damaged or lost, that you will be required to pay for a replacement device, and possibly additional criminal charges will be forwarded for prosecution. I have seen this with escape or fugitive charges that have come out after the fact. So this is something that you also want to pay attention to as well. Don't cut off your EMP bracelet and make sure that it remains fully charged. Will my residence be searched while I'm on the electronic monitoring program? The answer is a resounding yes. Participants' homes in the EMP program will be searched for contraband and, frankly, just searched for other items that you're not allowed to have while you're on the electronic monitoring program. This can include, depending upon the scope of the court's orders, something as common as alcohol.
Law is war, and your life is worth fighting for. ATAC Law. Your best defense is a good offense. Call now.
Do I need a home phone line to be on the electronic monitoring program? Well, generally speaking, you must either have a landline in the residence or a cell phone in order to make you eligible for the EMP program.
Law is war, and your life is worth fighting for. ATAC Law. Your best defense is a good offense. Call now.
My law firm can help you understand the legal process, help you build a strong defense against the charges, and work towards a favorable outcome for your case. Contact us today for a free case assessment.
Law is war, and your life is worth fighting for. ATAC Law. Your best defense is a good offense. Call now.